In the Shadow of Recognition, ASEAN's Missing Court by Kevin Crow. ASEAN has no central court, a familiar complaint. This article argues the absence is something stranger and more interesting than a gap. The missing court, Crow argues, is an epistemic condition, not just an institutional one. The ASEAN Charter speaks in a constitutional idiom: purposes, principles, compliance, inviting the appearance of a legal order while withholding the ordinary discipline of adjudication. So ASEAN legality gets made elsewhere, in domestic courts and in the compliance infrastructures through which banks and firms operationalize geopolitical risk. In domestic litigation, ASEAN law turns out to be an unstable category, less a coherent system than a portfolio of texts. Some texts bite, most are cited as atmosphere, which gets decided through domestic constitutional technique, citation, deference, and reception as selection. Each such decision quietly allocates authority between executive and judiciary and between the domestic and regional orders. The paper's theory is the translation zone. Domestic courts routinely convert public international law categories, recognition, engagement, treaty practice, into concrete private law and administrative effects. Banking compliance, contract performance, document validity, public policy exceptions. International questions go in, domestic consequences come out. Myanmar, after the February 2021 coup, is the forcing case. ASEAN's non-political representative device is often described as excluding the junta, but it is more precisely an attenuated non-recognition, a refusal to treat the junta as the proper bearer of Myanmar's voice. The UN did something similar with its credentials deferral, non-recognition by procedural avoidance. And Afghanistan under the Taliban supplies the comparative foil, the same dilemmas migrating to the same venues. Because no court ever says we recognize the junta. Instead, courts and regulators answer downstream questions. Are documents issued by contested authorities valid? Can this contract be performed without sanctions exposure? May the bank process the payment? Each answer produces recognition effects by proxy, largely unreasoned and largely unreviewed. The prescriptions are deliberately modest in form and demanding in implication. No ASEAN court by fiat. Instead, govern the translation zone, require reasons and evidence, demand explicit engagement with public policy rather than implicit executive deference, and discipline document validity rulings so that Myanmar-related uncertainty is argued as law, not absorbed as risk. Where interpretive authority is dispersed, determinacy is still produced. The question is by whom and with what discipline. In the Shadow of Recognition, Kevin Crow.